The Sixth Amendment of the Bill of Rights reads, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime, I'm Elmer Fudd now, sorry about that. The crime shall have been committed."
I like
Crime. Okay. "Which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. To be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." I think it's a little bit more intelligible if I just break it down to the rights that are inherent in the Sixth Amendment. There are 7 of them, at least, inherent in the Sixth Amendment. They are the right to a speedy trial, the right to a public trial, the right to be judged by an impartial jury, the right to be notified of the nature and circumstances of the alleged crime, the right to confront witnesses who will testify against the accused, the right to find witnesses who will speak in favor of the accused, the right to have a lawyer. Why do we have the Sixth Amendment? This is a good short paragraph by LegalZoom.com. At the time of the Constitution, English courts were controlled by the king. That means when and how a person was tried was up to the king or someone loyal to the king. Juries were never impartial. It was the equivalent of being tried by your accuser. If you were a peasant going to trial in the king's court, you might as well pack your bags for jail. The framers of the Constitution wanted to make sure the abuses people suffered in the English courts never happened here. Kudos to the founders. When the Sixth Amendment was ratified, it applied to federal courts, not state courts. And that caused some ripples down the road. We'll run into that shortly. And so it remained for a long time. But as ConstitutionCenter.org points out, around the mid-20th century, the Supreme Court ruled that virtually every aspect of the Sixth Amendment applies not only to federal, but also to state prosecutions. This vastly expanded the amendment's reach because most criminal prosecutions occur in state courts. Time doesn't permit comments on all 7 of this amendment's rights. I'll just comment on the right to a speedy trial and the right to have a lawyer. Again, from ConstitutionCenter.org. The court, and that would be the Supreme Court, of course, has held that the failure to begin a trial in a timely manner requires dismissing the prosecution entirely. Well, that sounds pretty good. But the article continues. Perhaps because that remedy is drastic, the court has interpreted the term speedy quite leniently. Delays of several years are sometimes permissible. So much for a speedy trial. The right to have a lawyer. I think this is an interesting little story. That's why I included it. So in 1961, a break-in occurred at a bar called Bay Harbor Pool Room in Panama City, Florida. One witness reported that Clarence Earl Gideon had left the pool room around 5:30 a.m. that morning, holding a wine bottle and pockets loaded with coins, and he entered a cab. The information was enough for the police to arrest Gideon. Gideon could not afford a lawyer. He asked the court to appoint him counsel. The court refused, stating that court-appointed lawyers were reserved for capital offenses. Gideon was left to defend himself without the aid of a lawyer. While Gideon maintained his innocence throughout, the jury returned a guilty verdict and sentenced him to 5 years in state prison, the maximum sentence. Inmate Gideon began using his time in the prison library to study the American legal system. He came to believe that the trial judge had breached his constitutional right to counsel under the Sixth Amendment that was applicable to the state of Florida through the Due Process Clause of the 14th Amendment to the U.S. Constitution. Armed with his newly acquired knowledge, Gideon penned a 5-page handwritten petition to the Court of the United States, Supreme Court of the United States. The Supreme Court responded, agreeing to hear the prisoner's case. That case was argued on January 15th, 1963. His lawyer argued that someone like Gideon, with no training in law, was no match against a trained trial lawyer. Accordingly, there was no way to have a fair trial without legal representation. On March 18, 1963, the Supreme Court handed down a 9-0 verdict in Gideon's favor. Gideon got a new trial, and after an hour of deliberation, the jury acquitted Gideon. He had spent 2 years in jail for a crime he didn't commit. So that's why we have today, even in local courts, public defenders, if the accused wants one. Gideon reflects the landmark ruling. Gideon clarified that the right to the assistance of counsel was a fundamental right of the individual, essential for a fair trial. This major procedural safeguard is a profound strength of our democracy. I would have used the term republic, based on the premise that no one should be charged by the state with a crime and then forced to confront the accusers in court without the protection of a lawyer.
Oh, thank you.
So, I think that's quite enough about the Sixth Amendment. And so I'm done, and I thank you for this opportunity, and may God continue to bless this great country of ours. Thank you very much.